Good morning, and thank you all for joining us today for this HR Bites session. My name is Kelly Hallett. I am Head of HR Team Service here at Harrison's. Our focus for today is annual compliance refresher because it is already the start of a new financial year. So it's a really good time to have a look at our core compliance pieces. It's a short session today, 15 to 20 minutes, just to get you up to speed on everything that you need to know about the topic. If you do have any questions, although we won't have time during the session today, our details will be at the end. If you want to give us a call or send us an email, we're more than happy to answer any questions afterwards. A little disclaimer before we get stuck into it. We're not lawyers. We're not here to provide legal advice. And we're also not providing any specific advice for your organisation, as each organisation and situation is unique. So the information we're providing is general in nature, and we would encourage you to have a think about how that applies to your specific context. Most of us in the session today have worked with or heard about Harrison's before, but just a quick refresher and an intro for those who haven't. Harrison's are an HR consulting firm. So we do your typical generalist HR consulting, including workplace relations, work health and safety, any strategic or operational HR matters that come up. We also have our HR team service, which is essentially where you outsource the entire HR function to us. We will put an HR manager on site with you and support in rolling out your strategic HR plan. We have a recruitment and onboarding stream. If you have any senior or hard to fill positions, we can certainly help with that. And then we also have My HR Experts, which is our online subscription platform, which is more of a DIY approach. It gives you all the info and tools that you need to be able to do it yourself. Starting with a recent headline here. So 32 staff at a Cairns restaurant have shared in a $24,300 back pay after the Fair Work Ombudsman found the business was inadvertently shortchanging workers. So this wasn't a conscious or intentional underpayment. It was a mistake, and they're easy to make. The restaurant's chefs and waiting staff were underpaid their minimum hourly rates, overtime, weekend and late night penalty rates over a period of 12 months. And how this was allowed to happen is that the employer was mistakenly paying the workers under an enterprise agreement that did not apply to that restaurant. So we're going to talk about award and classification compliance very shortly. And this is just a really good case study to highlight how easy it can be to accidentally classify an employee or employees under the wrong award or under the wrong enterprise agreement that can unfortunately have flow-on effects. So the way that this was picked up is that the Fair Work Ombudsman was doing a random audit of the restaurant as part of a national campaign focused on the hospitality sector. So that's the next piece. If there are misclassifications and underpayments, ideally you want to be the one to identify them first before an external body such as the Fair Work Ombudsman comes and does an audit. There are several other cases like this. Griffith University signed an enforceable undertaking as recently as the 12th of June. So they'll complete more than $8.34 million in payments, including interest and superannuation, to over 5,000 staff who were underpaid as part of entering into the EU. So there's lots more like this, and that's why it's a really good point in time to pause and have a look at our compliance. So, of course, compliance is important, but that's for a number of reasons. there is the legal risk to the organisation and specific managers within it, because legislative changes can impact your existing policies and contracts. Of course, awards and pay rates update annually and sometimes mid-year as well, just to catch us out. It also impacts your operational efficiency. So streamline relevant documentation supports your leaders and HR teams. It reduces ambiguity and improves consistency. People know where to go for information, that it's going to be consistent and reliable. And lastly, reputational protection. It demonstrates integrity and commitment to compliance, which helps to build trust within teams and also externally for your brand. And of course, prevents disputes and fair work claims, which can be costly and take up a lot of time. The high priority compliance areas that we like to focus on each year are pay and conditions, employment contracts, and your policies. So for 2025, your pay and award audit should include confirmation of the correct award. So this relates to the article that we've just spoken about. So you want to confirm which award are my employees covered by, and then individually which classification within that award is the most appropriate for that employee. Just because someone is paid above award does not mean that they are award free or that the award does not apply to them. We hear of that come up time and time again, and it is not accurate. So once you've classified your employees correctly, you can check your allowances and loadings and conduct a better off overall test where appropriate if you are looking to offset any of those entitlements under the award. It assists in preventing underpayments. It verifies your record keeping compliance in a way that's proactive. And of course, you want to be documenting the audit outcomes and actions taken so that if you need to refer back to them, you're not relying on your memory or the memory of someone who potentially is no longer with the business. It's all documented there and it is really clear. Secondly is reviewing and updating your employment contract templates. We do suggest to do this at least annually and then also ad hoc where there are legislative updates. So you want to have a look at what changes and updates have happened in the employment law space since you've last reviewed the contract template. So that might have been 12 months ago. That might have been a few years ago, depending on when was the last opportunity that you had to do that. Some things that you might want to look at if you haven't reviewed your employment contract recently is the updated definitions around casual employment, the pay secrecy terms and making sure that they're not in there, any max term and fixed term contracts, ensuring that they comply with the relatively new rules around maximum length and renewal. You want to have a look and make sure that the clauses in the contract are clear and they don't conflict one another, because we do see that from time to time. Ensure your flexibility clauses are compliant with the award flexibility options. What that means is that if you have a set off or a compensation for all legal entitlements clause or something to that effect in your employment contract, is that actually a allowed flexibility under that award? Because sometimes it's not. Sometimes you do need to use a facilitative provision or a separate individual flexibility agreement. So it's important to confirm that. And you want to protect both the rights of the employer, the organisation, and the individual employees. So some things that we like to review here when we look at employment contracts is not to include the position description as part of the employment contract. It should be a separate document, and certainly refer to company policies in the employment contract, but you want to really clearly state that the policies don't form part of the employment contract itself. Your termination clauses, review those, make sure notice periods and redundancy aligns with NES and modern award entitlements, because sometimes there are variations in the applicable modern award to these things. It might be a little bit different to the NES. Contracts are your first line of protection, so it's important that they align with the correct legislation and awards. Contracts need to reflect the current Fair Work Act provisions, including casual conversion, termination, probation, and flexibility, and using the correct employment type. So are they permanent, casual, fixed term, or max term? You want to include clauses on remuneration, location, reference to policies, confidentiality, and compliance. And of course, be cautious with offset or flat rate arrangements, because they require careful documentation, a better off overall test, and often an IFA. Harrison's did recently facilitate an HR Bite session exclusively on employment contracts. So if that's something you're up to review in the next few weeks, I'd highly recommend having a look at that session for a more detailed deep dive. And this is one of the things that was included in the previous HR Bites session, is running through what the important clauses are to include in your contracts. Reviewing your policies, training, and risks. So policy reviews are foundational. This year, things that you want to have a look at is your family and domestic violence leave. So confirm that the paid entitlement is reflected accurately, because there have been some changes in this space, and it was also a tiered rollout in terms of when it was effective for all businesses versus small businesses. Incorporate changes that were introduced under the Fair Work Act amendments around flexible work requests, which expanded eligibility and strengthened employer obligations. And have a look at the positive duty under the Respect at Work and Sex Discrimination Act. You want to ensure that your anti-harassment and discrimination policies meet the active obligation to eliminate sexual harassment, sex-based harassment, and hostile work environments. So these are the proactive approaches to eradicating these things from the workplace. Ensure that obligations for remote safety are clearly documented and supported with tools or checklists when we're looking at work from home and how that interacts with work health and safety, because we know flexible work options and work from home are becoming more and more prevalent. We want to make sure that we're doing it right. There have been changes in the parental leave space in as late as the last week, and then also last financial year as well. So check that your policy reflects those changes. Use the removal of gendered language when you're looking at your parental leave policies, and the ability to take leave concurrently, the updated entitlements and those sorts of things. And of course, there's the psychosocial hazard code of practice that has been implemented in the last few years. We want to make sure that we are proactively managing and remaining compliant with that, and that that's reflected in our policies as well. Having an awesome HR policy manual is certainly a good start, but that is not where it ends. We want to make sure those policies, whilst up to date and accurate and compliant, are also really clear for anyone who's reading it to understand and make sense of, and accessible, so that employees across the organisation at all levels know where and how to access it if they need to. Training is also really important so that you can demonstrate that you have taken reasonable steps to make the information available, but also to support your teams in understanding the way that those policies apply in the workforce. Training can be face-to-face, it can be online, it might be a toolbox meeting, it can be e-learning. The more different mediums that you can roll out, the better, because people obviously learn in different ways. And we want to be proactive in this space. So we want to be looking at risk assessments. We want to consult employees where it makes sense to do so in reviewing and updating our policies, and take preventative action where appropriate. So that is a very short, sharp overview of the annual compliance reset, and why July is a good idea to have a look at those three key things, being your award and classification coverage, your employment contracts, and your policies or policy manual. And compliance isn't just a legal obligation, it's also a cultural advantage, because if you do it well and you get it right, it protects your business, it builds trust, and it helps you to attract and retain great people. There's a QR code on the screen here. If you want to scan that quickly, that's going to take you to our free HR compliance checklist. So you can fill that out according to your own organisation. You will get the responses, and it can assist in sort of where to start in auditing, where your risks and gaps might be. Of course, Harrisons are also here to help. So we can do an award and pay audit for you as a standalone project. We can review your employment contract templates, create new ones for you, consolidate them if you've got too many floating around, and of course, develop your HR policies, procedures, and training, or the entire training, the entire policy manual, because sometimes it can be helpful to sort of roll that out in a way that's consistent and aligned. And again, that QR code is there for you to scan and complete that free resource for your own risk management mapping. Thank you all so much again for taking the time to dial in. As I said, we did do an HR Bites topic on employment contracts specifically recently, so jump onto the website and have a look at that one if that is on the top of your to-do list. Thanks so much.